නව Nokia 2.2 හැමදාම අලුත් වෙන Nokia වෙතින්.
වන විට ඉවත් කරන ලද විනිමය පාලන පනත
Today, we don't have provisions to take legal action under the Removed Exchange Control Act. As the Bank of Ceylon said, these monies had come when that act was in effect. What had happened was that they had not informed the BOC that this was a loan, and I explained it. The BOC does not accept it to be a loan. However, under the Exchange Control Act, which was in effect then, as a mechanism, we had given a general permission from 2013 to 2015 and then from mid-2015 to 2017, so the bank should do more. Since the bank was not informed that this was a loan, the bank does not have a general permission to repay it. The purpose of funds was not even mentioned in the SWIFT messages, and they were cited as personal transfers.
personal transfers වශයෙන් තමයි සඳහන් වෙලා තිබෙන්නේ.
අපිට මේ හිස්බුල්ලා මහත්මයා ඇවිල්ලා කියලා තියෙනවා මෙච්චර ගණන් ආවා කියලා. අපිට ලේඛනයක් දෙන්න පුළුවන්ද මේ දවස්වල මෙච්චර ප්‍රමාණයක් අවකාශ සම්පූර්ණ මුදල.
වාර 7කදී බැටික්ලෝ කැම්පස් එකකට වාර 15කදී හිරා ෆවුන්ඩේෂන් එකට වශයෙන් ලැබිලා තියෙනවා.
දැන් ඔය මේ 2015 තත්ත්වයයි 2017 පස්සේ තිබුණ තත්ත්වයයි මේ ඇක්ට් එක නිසා වන බලපෑම මොකක්ද?
ඔව් දැන් 2017 නොවැම්බර් 20ට කලින් සිදු වූ දෙයක් සම්බන්ධයෙන් ඩිටෙක්ෂන් එකක් කළා නම් ඒ පරණ ඉවත් කරන ලද පනත යටතේ විමර්ශනයක් කරන්න පුළුවන්.
මේ 2017 ගෙන අප සංශෝධනය
2017 ගෙන අලුත් පනත.
ඔය තියෙන කොහෙද ඒ වගේ දේවල් තියෙනවා නම් අපේ නීතිය පද්ධතියට ගේන්න බෑ කියන කොහෙද?
නැහැ 2017 පනතේ 30 වෙනි යෝගාන්තිය මගින් කෙලින්ම ප්‍රකාශ කරනවා විනිමය පාලන පනත මේ ඉවත් කරනු ලැබේ. එතකොට එහා සමග විනිමය පාලන පනතේ ක්‍රියාකාරීත්වය අවසానයි.
ඒ පනත ගෙනාවේ ඔබතුමාලානේ. ඔබතුමාලානේ හදලා එව්වේ. මොකෝ නොදන්නවා වගේ තියෙනවා.
නැහැ.
මහා බැංකුවෙන් 3-4 ගමනක් ඒක සංශෝධනය කළා ඔබතුමාලා එව්වේ ඒක.
No, sir. The act actually was not drafted by us.
Why not?
No, sir.
That is not by.
It was done outside the. We were actually very upset about that, sir. We were not included. The act was drafted without the central bank being involved, and then they were asked to comment on it.
ඔය මට හිතෙන විදිහට 2017 නම් අවසාන වශයෙන් බැටික්ලෝ කැම්පස් එකට මුදල් ලැබුණේ. මේ ඇක්ට් එක ඩ්‍රාෆ්ට් වෙනවා කියලා හිස්බුල්ලා මහත්මයා දැනගෙන ඉන්න ඕන. ඔව්. එම වෙන්නත් පුළුවන් ඕන.
දැනට විදේශ විනිමය පනත යටතේ වරද කියන වචනේවත් වරදක් අර්ථ නිරූපණය කරන්නවත් නැහැ. වරද කියන වචනේ මුළු පනතේම එකම එක තැනකයි තියෙන්නේ. විශේෂයෙන්ම දැන් මම නිරීක්ෂණය කරලා තියෙනවා unauthorized money changing රට පුරා සිද්ධ වෙනවා. ඊට පස්සේ අනිසි විදිහට සන්තකේ විදේශ මුදල් ළඟ තබාගෙන ඉන්නවා. පර්මිෂන් එක නැතුව money change කරනවා. ඒ money change $1ක්වත් අපේ ජාතික මූල්‍ය පද්ධතියට එන්නේ නැහැ.
CID එක අධිකරණයට වාර්තා කරනවා මේ මඩකලපුව කැම්පස් එක හදන්න සෞදි වලින් බිලියන 17.5 ලැබුණා කියලා.
මම අර කලින් සඳහන් කළේ බැටික්ලෝ කැම්පස් කොලෙජ් ප්‍රයිවට් ලිමිටඩ් කියන එකට ඩොලර් වලින් අපි ගාව ඉලක්ක දෙන්නේ ඩොලර් මිලියන 24,646,290. ඒ සමහරට FCI එක වාර්තා කරන්නේ නැති රුපියල් වටිනාකම වෙන්නේ නැති.
So in your opinion, what should be regulated any further? Because I think we are highly over-regulated and it is basically having an impact on the economy by itself. What more needs to be done?
No, I think there is a difference between regulation and monitoring. I think what happened is when we deregulated, when we liberalized, we also did away with the monitoring. So what we now have to do is to resurrect the monitoring systems so that we know what is happening. But we shouldn't regulate. I'm not saying we should regulate, but there are some gaps in our monitoring system which we need to fill.
Certain members would be my clients, and I would be appearing for those members of the cabinet who are members of this committee in these fundamental rights applications, and I would have to get instructions from them on the very same issues which you are called upon to deliberate as a committee. Now, in that situation, if this committee were to entertain me as a witness at about the same time, parallelly, when there is a court proceeding and the matter is sub judice, there arises an issue which should be seriously considered, that whether I am counsel, as Attorney General, I am counsel for the cabinet of ministers, President, Prime Minister and the entire cabinet. And I have to take instructions from you on the very same matters. And in those circumstances, are you in a position to deliberate on my testimony?
We are possessed of that.
Yeah, exactly. Deliberate on my testimony, which I will which I am called upon. No, that's not the only issue. Which I am called upon to give today. So I see a clear conflict of interest there.
What's the next?
The next issue is that now there are proceedings, including this proceeding, 2 other proceedings or 3 other proceedings, one in the magistrates court, where I have advised criminal investigation, and there is counsel from my department who is appearing to assist the police in that investigation. Now these proceedings can and will end up in future action. And apart from that, there are these fundamental rights applications, and I will be required to perform my functions as Attorney General. And in those proceedings, petitioner or any party respondent could submit my testimony before the court and make it part of the proceeding there, because that there is an attempt now at the moment, if you look at the pleadings, to bring certain proceedings of this committee before the court to further their cases before the Supreme Court. So in those circumstances, if my testimony is brought before the Supreme Court where I am counsel, it will compromise my role as counsel. So there is a conflict there, and if I am called upon to testify, this situation will necessarily arise. I envisage it happening because there are already applications. Then the next issue is that if tailoring it to the first issue I raised, there still can be objection that having given evidence before this committee, that I would be probably disqualified from appearing for certain members, members of the cabinet, and the cabinet as a whole could be compromised if I testify here. The other issue is that if I testify as a witness here, and the criminal prosecutions which are proceeding could result in a criminal prosecution upon indictment. And in the backdrop of that likelihood, I will have to present that indictment as the Attorney General. And if I am being cited as a witness in that trial or that criminal proceeding, by my ability to present that indictment will be compromised as the Attorney General. And my officers who are here today are able to present the evidence which I am called upon to do so. And they are here, they are ready. And there won't be a hindrance. The Commission's work will not be impeded or hampered. I have made arrangements to facilitate that process.
Mr. Attorney General, we have gone through carefully the several grounds on which you made submission. Of all of those grounds, we find one ground sustainable, and that is your unique role as one who signs the indictments. In your name, we have decided to allow your request for you not to give evidence.
Thank you very much.
Thank you. From the TID dated 7th June 2017, consisting of 25 pages.
Yes.
You have that letter?
We have.
Now, what is the advice that has been sought in that letter?
They have referred තවදුරටත් මෙම වෙබ් අඩවිය හරහා
They have sought advice on National Tawhid Jamaat and if it is a possibility to ban the websites and social media sites of National Tawhid Jamaat which spread extremist views, and if it is possible to arrest them and take legal action against them.
අත්අඩංගුවටගෙන විමර්ශනයක් සිදු කිරීමට හැකියාව ඇද්දයන් සම්බන්ධයෙන්
No, you answer the question, please.
Yeah.
Has there been a reply sent to that letter? In writing?
in writing no reply.
No reply has been sent. Almost a year later,
Yes.
and saying they have still not received a reply to the letter that they sent you.
Yes.
And they want a reply to that.
Yes.
Right? In addition, what have they sought? Something about Zahran?
Yeah. Mohammed Qasim, Mohammed Saharan යන අයට විරුද්ධ
It says it seeks advice since there is no response to the letter with the reference number EER 2017, which requested measures that should be taken about Mohammed Zahran and Mohammed Qasim.
ලබා දීමට අවශ්‍ය කටයුතු සලසා දෙන මෙන් කාරුණිකව ඉල්ලා සිටිනවා. On 12th of March 2019, after studying these documents, Mr. Malik Qasim called for a consultation. Yeah. They were present for the consultation in the Attorney General's department. පළවෙනි ලිපිය සමග ලැබිලා තියෙන්නේ මේ වෙබ් අඩවිය වල ස්ක්‍රීන්ෂොට්ස් විතරයි. එහි අන්තර්ගතය පිළිබඳ පිටු 9ම සඳහන් වෙලා නැහැ.
මගේ විශ්වාසය මැක්සිස්